Hello students, welcome to today's topic on EWS reservation. Recently, Supreme Court said that EWS economically weaker section reservation is constitutionally valid. Like that, it is in news now. Now, detailedly know about reservations in India. In these cases, first case is Champakan Dorairajan case. In this case, Supreme Court said that there is no reservations on caste base. This Champakan Dorairajan case is mainly on backward classes reservation, but Supreme Court said that there are no reservation under caste base. In our constitution, Article 16 class 4 tells us about reservations at jobs or employment. Simply say that reservation at employment by 16 class 4 and 15 class 4 for reservation at educational institutions. Later, VP Singh government time, Mandal Commission report implement this BC reservation. Okay, BC reservation started at VP Singh government time. First, this Mandal Commission report is called second BC Commission, and first BC Commission in 1953 under Kaka Kalelkar Committee. Under this second BC Mandal Commission report at VP Singh government time, BC reservation is 27%. And later, the second case is Indira Swahane case. Okay, second case on reservations is Indira Swahane case. First case is Champakan Dorairajan case and second case is Indira Swahane case. In this Indira Swahane case, this is also called as Mandal case. It is also on BC reservations. In this case, Supreme Court said that BC reservation is constitutionally correct and constitutionally valid one. Later, P.V. Narasimha Rao time. P.V. Narasimha Rao, economic reforms, LPG reforms, okay? And P.V. Narasimha Rao time, he asked on EWS reservation. At that time, Supreme Court said that EWS reservation is not valid under Constitution. This second case, called Indira Swahane case, Supreme Court said that EWS is not valid according to Constitution and reservations in promotions is also not valid and reservations not more than 50%. Okay, and creamy layer also introduced for BC reservation. Okay, reservation is based on income limit is called as a creamy layer, and next creamy layer also introduced in the case of Indira Swahane case by Supreme Court. Later, 1/3 Constitutional Amendment Act was introduced for EWS reservation also. Okay, 1/3 Constitutional Amendment Act was made for EWS reservation. Okay, it is under Article 15 Class 6. Article 15 Class 6 for educational institutions and Article 16 Class 6 for EWS reservation in employment. Okay, EWS reservation is 10%. Already we have backward classes reservation 27% and SC, ST 15% and 7.5%, totally 49.5%. Okay, in Indira Swahane case, Supreme Court said that reservations not exceed than 50%, not cross 50%. But here, when we add EWS 10%, it is crossing 50% as 59.5%. So, petitioners ask court, why reservations cross 50%? Is it valid or not according to Constitution? Reservations cross 50% by introducing EWS 10%. Is it valid or not by the Constitution? Okay, and also economical reservations is present or not, it is correct or not by Constitution. And petitioners also ask that in unaided educational institutions, this EWS will work or not. Like that, 3 questions will begin in petitioners. Okay, first one is reservations cross 50% or not, and next one, economical reservations is correct or not by Constitution, and third one is in unaided schools, educational institutions, this EWS method reservation is present or not. Like this, questions will arise in people. So petition was made into the Supreme Court. Supreme Court said that 10% economical weaker section, Okay, reservation is not damaging. This concept is not damaging the basic structure of constitution. It is constitutionally valid one because in the same seats of BC, SC, ST 50%, we are not giving EWS reservation. We adding 10 seats to more. We adding 10 plus seats more for EWS and giving this reservation to EWS people. This not damages the rights of SC, ST and BC. And Article 19G for occupation also introduced in Article 19 in our fundamental rights. In private institutions also, this EWS and SC ST reservations will applicable. This case solved by 5 judges bench in Supreme Court because it is related to constitution. So 5 judges bench solved this. In these 5 judges, Chief Justice of India U Lalit and Ravinder Bhatt opposed this EWS reservation and remaining 3 judges favor to this. So this bill is passed and finally it is saying that EWS is constitutionally valid. Today many high courts are thinking about this Supreme Court judgment. The decision made by Supreme Court and EWS constitutional validity is correct or not. In this way, many high court justices are thinking about it. This is about EWS reservation, what recently passed in Supreme Court and reservations in India cases.